Good morning. Welcome to AMSA's webinar titled Changes to the Cannabis Act, How to Support Newcomers to BC. Before we start, we would like to thank Immigration, Refugees and Citizenship Canada, IRCC, for funding today's event. And so we have 3 different presentations, and we will be having a Q&A session after each presentation. So our first presenter today will be Dobson-Mack of WorkSafe BC, followed by Ryan Element with the RCMP. And our final presentation will be by Erin Roth and Randall Cohn of Edelman & Company Law Offices. And as I mentioned, we will be having a Q&A session after each presentation. So I'd like to introduce on the next slide our first speaker for today. Dobson-Mack is a lawyer who has been with WorkSafe BC for 15 years. She is currently a senior prevention advisor in the Prevention Practices and Quality Department, providing legal and policy advice on occupational health and safety matters. So Anne is here today to talk about health and safety in regards to cannabis. So looking forward to hearing your presentation, Anne.
So I just wanted to give you a little intro just to explain what WorkSafe is. I'm sure you're all aware of who Immigration Canada is and who the RCMP are, but WorkSafe, the legal name of WorkSafe is the Workers' Compensation Board of British Columbia, and we have kind of a hybrid function. We deal with insurance claims, the compensation claims for workers who are injured, but where I'm coming at this from is the prevention side, which is the occupational health and safety side of our business, and that's to prevent injury from happening. So we what I do is give legal advice and policy advice to the officers in the field who go out and inspect workplaces for infractions or for compliance. So just a little overview was I'm going to talk a little bit about legalization of cannabis, impairment at work, and the regulatory framework, which is basically the occupational health and safety regs, the legislation that governs impairment at work. What are the workers' obligations under the regs? What are the employer's obligations under the regs? And then resources, which is mostly from an employer's perspective, where employers can find resources to help them manage impairment in the workplace because it's the employer's responsibility to do that. So our message has been that cannabis use is just one aspect of workplace impairment. So there is a broad requirement that workers be fit for work. That's our big message, is you have to be fit for work, which means you can't be impaired for any reason. You can't be impaired because you've drunk alcohol, because you are fatigued, because you are taking some prescription medication that causes you to be not able to do your job safely. But additionally, cannabis is another obvious form of impairment or cause of impairment, and that is what has given us the opportunity to talk about this matter with a lot of people, because with the legalization of recreational cannabis, people are taking the opportunity to update their impairment and substance use and rehabilitation and that kind of thing policies in the workplace. So workplace impairment due to cannabis isn't new. As anyone from the Lower Mainland knows, there have been probably at least 100 non-licensed medicinal marijuana dispensaries prior to the legalization. So it was readily available and fairly frequently used. The question we were wondering was, would legalization cause an uptick in use on like the non-medical use, the recreational use? And Stats Canada did a survey, which they published February 7th, just earlier this month, and it said they found that the number of cannabis users has remained relatively unchanged since legalization. So that's kind of a good news story. Our big message is there isn't really a magic bullet on managing impairment. There's nothing really easy you can do. What you need to, our big focus is on observation and like supervising and management. The responsibility is on the employer to make sure that their workers are able to do the jobs you've assigned them or the tasks you've assigned them safely, and it's the employer's obligation to observe and have systems and education in place to make sure workers know what their obligations are and how to report if they are impaired or if they notice that a coworker is impaired. And I'll get a little more into that later. Yeah, so we're taking this as an opportunity for employers to look at their policies and procedures and update them around the legalization of cannabis. So the post-legalization questions we're having are: how can an employer determine impairment? Zero tolerance policies. Now that cannabis is legal, are zero tolerance policies legal? When can employers require testing? And are we creating new regulations to deal with cannabis use at the workplace? So I'm just going to answer those quickly. How to determine impairment? I think probably everyone's familiar with the roadside testing kind of testing used by the police, and they're still using that. There are courses that are available online. A lot of occupational health and safety organizations are providing online courses that we recommend employers send their supervisors to. Anyone who's in a role where they're responsible to observe workers or have workers reporting to them as to substance, any impairment they may observe. Zero tolerance policies, are they legal? I think what you need to ask yourself is, the easy way to ask is, would you have a zero tolerance? Would you deal with alcohol in this way? Would you have a zero tolerance policy for alcohol? Because alcohol has been legal for a long time. If the answer is no, then you have to ask yourself, well, why would I be having a zero tolerance policy for cannabis in that case? Now, the difference between alcohol and cannabis that's important is that alcohol isn't ever prescribed or used medically, whereas cannabis may be. So employers have to make a distinction between their workers who may have a valid prescription for a condition for which they're taking cannabis medically, and employers are going to have to accommodate those workers as much as they can. Not so for recreational. Or if they have a substance abuse problem, that's another disability. So employers would have to accommodate someone with a substance use problem, because that's another human rights matter where there is an obligation to accommodate. So that would be true of any substance addiction, not just cannabis, but it's just raised that question. When can employers require testing? That's an interesting one. Employers are going to put it into their policy. The times when they tend to have been permitted to use testing is pre-employment, when they haven't decided whether they're going to employ someone yet, and they want to do a blood test or a test to see if this person has used any substances recently, or if they have an addiction problem before they hire them. Then testing often happens after an incident where impairment is considered to be a possible cause of the incident, where impairment has been considered observed, or where there's a reasonable likelihood of impairment. When someone observes signs of impairment and they think they're questioning, could this be related to a substance, or could it just be fatigue or stress in the person's life? So that may be a case where you're thinking about using testing. Random testing is very, very, very rarely supported in the courts. There are very few workplaces in the oil patch where there has been found to be an impairment problem in a workplace and it's known to be causing safety hazards. That's one case where it has been found, a random testing has been found to be permissible. But other than that, it's very strongly frowned on as an invasion of privacy rights. And we are not creating new regulations to deal with cannabis in the workplace, because we've had impairment regulation in place for 20 years now, and it will apply to impairment caused by any physical impairment or substance use, fatigue, stress, all sorts, any kind of impairment that has a negative impact on safety in the workplace. Okay, yeah, so as I was saying, cannabis use isn't new. In the past decade, before legalization, there was a 61% increase in daily and weekly cannabis use. This is the 25 to 44-year-olds are sort of the key employment demographic, so that's what we were interested in. Use at workplaces, 78% of the people polled said they hadn't used it at all. 10% said less than once a month, 4% monthly, 8% weekly or daily. And then the trend we're finding is that there hasn't been a great change. Yeah, so impairment work, physical or mental impairment, they can all affect a person's ability to work safely. Yeah, it's not limited to cannabis, and it's been regulated for some time. So if you're interested in where this comes from, it is the kind of ironically numbered 420, is the impairment reg. This is the one that deals with alcohol, drug, or other substances. The focus is what will make the workplace unsafe. So impairment isn't just, you look a little odd or you smell like cannabis. Impairment is going to be, have you taken enough of any substance or had enough stress in your life that you are unable to safely perform your job. So employers are going to have to look at all the tasks that their employees do and determine which of them are likely to be impacted by impairment. So someone who's a heavy equipment operator or someone who's driving is obviously doing what they call a safety sensitive or risk sensitive job, then that is going to be something where any amount of impairment could make them unsafe. Whereas an office worker, someone who's, say, typing all day, is going to you're going to do a very different hazard assessment. So it's a task-by-task analysis that needs to be done by employers. There's no standard rule, or there's no magic bullet, as we were saying earlier. And then this is the broader reg is physical or mental impairment. The 420 was the substance use, and then this is the broader physical or mental impairment. And it requires that a worker that has a physical or mental impairment that could affect their ability to safely perform the work that's been assigned to them, they have an obligation to inform their supervisor or employer of the impairment, and they have an obligation not to knowingly do work where the impairment could create an undue risk to them or to anyone else in their workplace. And then at the same time, the employer has an obligation not to assign activities to a worker where there's been a reported or observed impairment that could create an undue risk to the worker or anyone else. There's also, so those are the specific obligations under the occupational health and safety regulations that deal with impairment. Then there's the more global or general duty obligation under Section 115 of the Workers' Compensation Act, and that's just the global duty for employers to ensure that the workers in their workplace are safe by making them aware of the hazards, remedying any hazardous conditions, establishing policies and programs, and providing information, instruction, training, and supervision. And due diligence is a defense to those any orders under Section 115. Worker obligations are to take reasonable care to protect their health and safety and that of others. That's in the Act. And they have to comply with the Act and the regs. So that includes ensuring their ability to work isn't impaired by alcohol, drugs, or other substances, telling their supervisor or employer if their ability to work safely is impaired for any reason, and reporting contraventions. So if they need to report to their supervisor or employer if they see someone who appears to be impaired. It doesn't mean they need to take any action other than telling the supervisor or employer, and then the supervisor or employer needs to have a system in place to deal with that in a confidential manner and timely manner. Yeah, so the employer obligations are for impairment are what will affect the worker's ability to safely perform the assigned work, that's impairment, or the ability to work is affected by alcohol, a drug, or other substance so as to endanger the person or anyone else. So there's a focus on safety. It's not a focus on productivity. That's maybe a human resources, labor relations issue. That's not WorkSafe BC's business. We are focused on impairment that affects safety. We recommend functional impairment testing as opposed to biological or biochemical testing because it's not going to be invasive into people's privacy rights. So the kind of training that we are recommending employers send their supervisors or managers to, people who are in a position to be reported to as to observed impairment or to be responsible to observe and supervise people who are impaired, is the kind of testing that will look for decreased motor control, reaction time, and sensory perception. So it's like the roadside sobriety test. Impaired judgment, thinking, decision-making, and focus, or psychological or stress-related effects such as mood swings or personality changes. So those aren't just going to be caused by substance use. Those can also be caused by stress in someone's life. And where our safety officers are going out to look for compliance, we are they're globally looking at safety in the workplace. And when they're looking for impairment issues, they're going to look for any signs pointing to impairment issues as a way to start a conversation to ask, do you have an impairment policy? Do you have an impairment management system in your workplace? What does that look like? what training have you provided to your supervisors and managers to identify it? What training have you provided to your workers to ensure they are fit for duty, so that they know how they would report it, that it will treated in a confidential manner, that the reporting will be done in a safe and kind of confidential place where they're not necessarily being observed by their coworkers. And policy, yeah. So do they have an active policy, and how are they enforcing it? Because it's nice to have a policy, but if it's sitting on a shelf and not being enforced, it's not making the workplace any safer. Yeah, so we need to see some evidence that the workers have been trained on the policy, the supervisors have been trained on identifying signs of impairment, that they've been trained on a procedure to follow if they do see signs of impairment, and they don't just assume it's due to cannabis use or alcohol or some other substance. It could be, fatigue or stresses in someone's life. How actively are workers being managed? Because we're relying on observation, so that there's going to have to be a pretty close supervision of workers in order to be aware of impairment in that case. Or is the employer turning a blind eye to workplace impairment? Do they have no policy? Do you see signs of cannabis use or other drug or alcohol use in the workplace that make an officer concerned that there may be an impairment issue that is being ignored in a given workplace? Testing isn't required by the Act or the regs, but it could form a part of the impairment management program, depending on the level of risk in a workplace. If it's a high-risk workplace, for instance, where there's driving or heavy equipment operation or operation of dangerous equipment, those are the safety-sensitive kind of jobs where you may want to have testing after an incident, say, or pre-employment testing. But testing has a very limited application for cannabis. I'm sure the other people are going to tell you that there's actually no way to it's very difficult to test for impairment for cannabis because it sits in the fat cells for a long time, and chronic users could have a really high level in their fat cells. It doesn't actually mean they're impaired, whereas someone who hasn't used it before may have a very low level of, well, THC is the psychoactive element. So someone who has no experience may have a very low level of THC and be very impaired. So that's why we say it's better to do take a functional approach rather than just this biochemical testing. Yeah, so we say testing can't replace effective oversight, supervision, and management in the workplace. And as I mentioned earlier, testing does raise human rights and privacy legislation issues. Okay, so for more information on cannabis and other substance use impairment in the workplace, WorkSafe BC has created a landing page it's on www.worksafebc.com. And then if you do a search for substance use impairment, you'll get to this landing page, and we have created a bunch of tools. We've got a toolbox meeting guide, which is something that employers can use, say, for their kind of the toolbox meetings they have daily, or the tailgate kind of meetings they have, to talk about what are the employer's obligations, what are the workers' obligations. There's also a guide we created which tells an employer how to create a policy, what elements they're going to have in a policy, where they might want to get legal advice on their policy. And we've also got links to other good resources. The Canadian Centre for Occupational Health and Safety has some fabulous resources for what are the signs of impairment. They have an e-learning course on cannabis and identifying cannabis impairment. And they have an incident reporting, it's a substance use impairment incident investigation checklist or tool, so that if a supervisor, say, has reasonable cause to believe someone may be impaired, it tells them, it gives them an ability to investigate. They'll write down who the witnesses are, when they saw, who they saw, what were the signs they observed. So they're not just kind of willy-nilly making assumptions that because someone looks a bit off, they are impaired by cannabis or some other substance. It kind of keeps them within a reasonable framework. Yeah, so these are our resources that we created. The Canadian Centre for Occupational Health and Safety has some fantastic, they've got like frequently asked questions, that kind of thing. So very simple, very helpful information. The Canadian Standards Association is developing a workplace impairment standard. That's just in its infancy though, so that won't be out for a while. So the key points is that impairment isn't a new issue. Our existing occupational health and safety regs require that a worker's ability to work safely can't be impaired by alcohol, drugs, or other causes. The worker has to advise the employer if their ability to work safely is impaired, or the worker observes someone who is impaired. An employer has an obligation not to assign an impaired worker to activities where it may create an undue risk. And they also have to remove a worker who is impaired. So there are key messages that employers need to actively monitor the workplace, supervise workers, and develop and enforce policies and procedures for their workplace. And that's my contact information if you have any questions.
Thank you so much, Anne. And if we go to the next slide, we'll be able to see how you can submit your questions for Anne. So we do have our first Q&A session. So please type in your questions into the question box, tweet them using the hashtag AMSA events, or email them to events@amsa.org. And so the first question, Anne, that I received, you kind of answered it a little bit, but if you can maybe expand on it a little bit more, is you touched upon that there are courses that supervisors can take part in to learn more about how to identify impairment and kind of the next steps that they need to take. Could you expand and explain a little bit more about that?
Yeah, it's not that WorkSafe doesn't provide anything like that. We're not in that business, but we can. There are occupational health and safety training organizations out there. So if you just Google occupational health and safety training, they'll take you to the websites of the training businesses, and a lot of them have developed cannabis impairment training online or live. That's not something we provide, but that's how I would do it. I would Google occupational health and safety training, and like one of the big trainers is an organization called Can-Am. They do testing and they also provide training.
Okay, perfect. Sorry, the question regarding the course is, does that have to be a BC specific course, or can it be a Canadian or course in general?
It's up to the employer to find something that in their area that works, but it's not BC specific at all.
Okay, perfect. Thank you so much, Anne. And another question that came up was a little bit regarding that policy creation. Could you maybe explain and elaborate more? What should an organization be thinking of when they're looking to create this policy that you were talking about?
What I would do is I would go back to the resource. We created a resource which is a guide. Okay, yeah, it's called, if you go to the WorkSafe BC website and then you type in substance use impairment, then under our resources, the one we created, which is really helpful for this, is called Managing Workplace Impairment and Developing a Substance Use Impairment Policy. And that gives you a template, which is really basically, you're going to fill in specific information that relates to your workplace and the hazards in your workplace. But if you go through that, it will take you through all the things you need to consider to develop a policy that will manage impairment in your workplace.
Okay, perfect. Thank you so much, Anne. And one other individual asked if we could also go back the one slide just to look at your contact information. If you could just elaborate a little bit more. Is this in terms of people have questions about this presentation, or in regards to this general to contact you? Yeah,
so to contact me is my email. To report any kind of occupational health and safety issues or ask general questions, you'll use the toll-free or the general phone line. That will get you through to occupational health and safety prevention area of WorkSafe BC generally.
Okay. And you also mentioned the word regs a couple of times in your presentation.
Regs. Oh, regs.
Yes.
The occupational health and safety regulations.
Okay.
Yeah, regs. Yeah, sorry, the regs.
Okay.
As opposed to the legislation.
Okay, what's the difference?
Okay, so well, the occupational health and safety regulation is developed. It's kind of interesting. It's developed by WorkSafe BC, and then it is promulgated by or approved by cabinet, and it becomes law. But it is developed in-house because we've got the expertise to know what makes sense in a given safety situation in a workplace. But yeah, so it's lesser legislation, but it is still binding on the employer and the worker.
Okay, perfect. Well, thank you so much, Anne. That was all the questions that we received. So it looks like you did a fabulous job explaining everything. And so there wasn't many questions left. And we did share your contact information in the slide previously. So if somebody does have some questions, they can follow up with you after that. Thank you. And so I'd like to now go to our next slide and introduce our next speaker, Sergeant Ryan Element from the RCMP. Sergeant Element is a team leader for the Surrey Drug Team Unit 2, and he has been a member of the RCMP for 18 years with the majority of his cases, for the majority of his service. 12 years as a drug unit member in the city of Surrey, and Sergeant Element has been involved in hundreds of controlled drug and substance investigations, ranging from street-level drug sales to large drug importation, distribution, and trafficking networks. So thank you so much for being here today, and I'm looking forward to hearing your presentation.
You're welcome. Hello, everyone. So when you look at the implementation of the Cannabis Act, which took over cannabis investigations that were previously covered by the Controlled and Drugs and Substances Act, that started on October 17th. The implementation of the new act has not been without problems, as most of the government agencies come October 17th, we weren't quite ready to deal with cannabis legalization. Such concepts of ticketing systems and retail sales, those were completely ill-prepared for October 17th, which left us in a little bit of a conundrum on how we go ahead. So when you look at the new Cannabis Act compared to the old Controlled Drugs and Substances Act, every offense that was previously listed on the Controlled Drugs and Substances Act has an equivalent on the Cannabis Act. So even though cannabis is now legal, there's a whole bunch of things that can get you in trouble in regards to cannabis, much like the use of alcohol. So although you were allowed to legally possess marijuana before, you weren't allowed to under the Controlled Drugs and Substances Act. Now you can, but there's stipulations for how much you can have, how old you need to be, a bunch of different aspects that we'll go through. Trafficking, which is selling drugs. Again, there's two separate ones under the act now for selling and distribution. The difference being selling, actually you're doing a financial transaction to getting the actual cannabis, whereas distribution could mean you're giving it to people who shouldn't lawfully have it. So there's a bit of a distinction there. Possession for the purpose of trafficking, again, deals with there's a certain amount that you're allowed to have. And if it's greatly in excess of that amount, we can go with a charge of possession for the purpose of selling. But those are all like aspects that are we have to actually investigate to produce charges. Possession for the purpose of trafficking, that means you have more marijuana or more cannabis that we believe you should lawfully have, and that could equate to us believing that you may be unlawfully selling marijuana. So there's still an offense under the Cannabis Act for that. And that falls with production. You can lawfully now grow marijuana in your residence. There's also stipulations that said you always could under various medical licensing. But under the Cannabis Act, there's a whole bunch of stipulations for you to be able to lawfully do that. Okay, so possession. Now, it gets complicated. So people need to know and understand under the Cannabis Act, this equivalency mount chart. Now, there's 7 different types of cannabis, and each has an equivalency of 30 grams of dried cannabis. This is complicated, and it takes a little bit to get used to it because how it breaks down, you almost need to understand a little bit of mathematics to be able to do this properly. So cannabis allows you to have 30 grams of dried cannabis. This is recreational use. There's a whole bunch of different stipulations for how much you're allowed to have medically. Or the equivalent of 30 grams of dried cannabis in public. So you can walk around with a bag that contains 30 grams of dried marijuana or a whole bunch of other stuff, but it can't exceed the 30 grams of dried marijuana according to this calculation that we'll go to on the next slide. And there's no limits to what you can possess at home. Much like someone who enjoys wine will have a whole wine cellar. If you by chance have a whole room full of marijuana, legally you're allowed to do that with your various strains and however you like to use it. This is lawful. But in movement, if you actually have it on your person, it's 30 grams or the equivalent of 30 grams according to the next graph. So there's 7 different types of marijuana. Now, you have your dried marijuana, which is probably what most people think of as what you're going to roll up into a cigarette or what you're going to put into a pipe and actually smoke. Fresh marijuana is fresh plant. It's a little bit hazy, the photo, so sorry about that, but I can explain it. Solids containing marijuana, cannabis. Non-solids containing cannabis. Non-solids would be like everything. When you look at cannabis now, there's a whole line of product that far exceed the dried cannabis. So You have cannabis-infused pop, cannabis-infused cookies, cannabis-infused gummies, all of these aspects. And these 7 categories cover that. Solids containing cannabis could be your cannabis cookies. Non-solids containing cannabis could be your drinks. Cannabis solid concentrates are when you're rendering down the various oils, like your shatter, like marijuana, various THC oils, your tinctures, all that type of stuff. Non-solid concentrates, same aspect, and plant seeds. Now, plant seeds is 1 seed that it equals into a marijuana plant. Now, when you look at the chart, so it's still, you're allowed to have 30 grams of dried cannabis or the equivalent, but if you have 30 seeds, well, that is your equivalent. So you can, if you have 30 seeds on your person and you have 30 grams of marijuana, technically you're in contravention of, you're in overage of your possession. Comes down to a law, when you look at the concentrates, it's actually quite a bit less. Now that, they do that because the concentrates have more THC or are definitely a stronger substance. Technically right now, under the Cannabis Act, and it again shows you how the implementation is still rough in its go ahead, is you're allowed to buy dried cannabis now, but nothing, there's no legislation now that's saying that you can lawfully purchase edibles. Now that's your gummies and all of the other aspects of it. But the Cannabis Act says, the Cannabis Act stipulates that this is going to be ironed out fairly soon. So again, in a policing context, this leaves us sort of in a conundrum. Technically, you're not allowed to have it, but even in the act, it says, well, we haven't figured this out yet, but we fully plan on figuring it out. So it's going to be legal in about a couple months. So it leaves us in a little bit of a strain. But that's the one thing you got to remember is if you have 30 grams of dried marijuana on you, you're technically not really allowed to have any of the other ones. And then you have to break down the equation to make sure you're under that 30-gram cannabis amount, dried cannabis amount. It does. We have a course that we do as Mounties to go through this, and half of it is 15 equations of us breaking it down to see if they're in contravention or not. So it's a tad complicated. So medical purpose users. So that existed prior to the Cannabis Act and still exists to this day. Now, you can lawfully, if you are a medical user, you can lawfully have up to 180 grams in public. That is a lot. So it's a 30-day supply or 150 grams, whichever is less. So that's whatever the doctor has prescribed for you. If it's 3 grams a day, well, then you should only have 90 grams. But you're also allowed, so you are lawfully allowed to have a certain amount that the doctor has prescribed, but you are also lawfully, in addition to that amount, to have 30 grams for recreational use. So it's a little odd that you could have 180 grams, and that includes 30 grams of recreational use, and the rest of that would be the equivalent of whatever the doctor says you're allowed to use. That equivalency chart, again, will help you understand kind of how that works legally. And it has to be from a doctor or other medical practitioner. Like a lot of these marijuana stores that are cannabis stores is not fully legal. They somewhat self-prescribe that. That's still not really a go. Selling and distribution, again, only lawful adults 19 years older. Again, that's in British Columbia. Different provinces get to set the standard for that, to purchase cannabis from provincially licensed retailers. This includes storefronts and online purchases. Purchased cannabis must come in approved packaging, and it's unlawful to give, distribute, to sell cannabis to a young person. A lot of the act has to do with trying to dissuade the young from lawfully possessing cannabis, much like the alcohol acts. I'll go over quickly what constitutes approved packaging, what constitutes a store, what's a storefront, and what constitutes online sales. But again, a lot of those are still in flux. Production, you're allowed to have 4 plants in your house, 4 total. And this is the big one. It's prohibited to alter, physically change the cannabis by using organic solvents. So very briefly, when you have marijuana plant, it down to a more potent THC level, trying to render it down to oils. The best way to do that is by using organic solvents. Now, organic solvents are very flammable. And when you see on the news, the house exploded because they were doing butane honey oil, which is a way of reducing a marijuana plant to a THC concentrate, and the house blew up because of the organic solvent being completely flammable. This is going to be a problem for us going forward. There is a whole system for medical growers that existed prior to the act, and that is still being honored. So if you have medical licensing from before and you still have more than 4 plants, but the medical licensing said you could have 30 plants, that is something that we take into consideration. Okay, so very quickly, this is by the most, in a policing standpoint, for the public standpoint, this is the most dangerous aspect of cannabis. The use of organic solvents to create these oils. Now, over the last 3 years, I've probably been to about 10 of these houses that have caught on fire or semi-exploded, people running out of the house in semi-states of on fire. So these things potentially are a huge risk. When marijuana was legalized in Colorado, they had a huge spike, like 160% of like houses exploding because of this rendering of marijuana. We haven't had that yet, which is quite lucky in our part. So impairment. So as this is a developing field, approved screening devices are being studied for its implementation, similar to alcohol screening devices. So the RCMP is currently not using one, but other police departments are farther ahead than us. The science and the study of what constitutes impairment by cannabis is still in its infancy. So it's the one that we're considering uses saliva as a means to determine concentration in your blood levels to see what level of impairment you're at. But the particular one that we were looking at does not do well in cold environments, and like this is Canada, so we had to scrap that. But other police agencies are working on other ones, and it's going to be, a lot of this is going to be up to the courts to figure out what's the validity of these tests using these particular detection methods. So that's one. So Crown Counsel, they decide if charges do get approved, and charges for possession will be considered if you are in excess of 50 grams. So like everything that in a policing context, police have the discretion to enforce via ticket, enforce via charge, enforce via different means. And we do use that a lot. So the difference between that member to member can be different. One may go straight to an actual charge. One will be going maybe by a federal ticket. And one may just take the excess of marijuana and write that up as a report. So with 30 to 50 grams, we're planning on enforcing it by a federal ticket. Now, again, when October 17th hit, these tickets were not even, they were in draft mode, but hadn't actually been out in implementation. Now they are now coming out into effect, and we can enforce by a federal ticket and provincial ticket. So if the accused decides to fight the ticket, which is of course your right to do, the police then have to prepare this. Granted, it's terminology, policing terminology here, but it's a very extensive report that has to go to Crown, and that Crown Counsel will be responsible for prosecuting federal tickets, which is it might be quite heavy for them, might be quite heavy for Crown. Federal and provincial tickets have come online and are currently enforceable. Cannabis Act production charges will be considered for anything over 10 plants, under 10 plants, and will probably go by the way of the federal ticket.
So before we move to the next slide, we just had a couple of questions. If you could explain what is Crown Counsel and what is a federal and a provincial ticket?
Both federal government and provincial government, they can write tickets in regards to how the Cannabis Act is going to be enforced. Generally, they kind of mirror each other, but the province and the federals can have their own stipulations, along with a whole bunch of municipal tickets that the city decides to put forward. Crown Counsel is our prosecutors. They have to handle, when we forward actual charges for drug offenses, it's a federal Crown that handles it, federal Crown Counsel. And for the tickets, if you decide to fight it as a citizen, which is of course your right, then it's going to be the responsibility of federal Crown to prosecute the federal ticket.
Okay.
Cannabis Act production, we're considering for anything over 10 plants, anything under 10 plants, we're probably going to go by the way of the federal ticket. And this is the one thing that we're all, quite frankly, a little bit scared of, is the houses exploding with people running out on fire. It's a bad day for everybody. So Crown Counsel has, in consultation with them, they will pursue that with a little bit more vigor than they will the rest of the Cannabis Act stuff, because they pose such a threat to police and public safety. Provincially licensed retailers. Now, this is probably the biggest stipulation. I'll very quickly go through this because it's where you can lawfully buy. This is where it's very much in flux right now, because the cities themselves have a say on how many provincially licensed retailers are allowed in their city. They get a say. So provincially licensed retailers. Now, this is where there's still a lot of flux in the system in regards to where you can lawfully purchase your cannabis. You're allowed to purchase it on legal BC liquor stores. Now, not all of them are going to be selling marijuana, but certain are. And then the cities themselves, under the municipal governments, they get to choose how many of the lawful storefront marijuana stores they're going to have in their cities. So if you look at the news recently, Vancouver has a lot of them. Only 2 of them right now, only 2 out of a whole bunch are actually have done everything that they've had to do to be completely lawful. Where I'm from, Surrey's council right now has taken the stance of none in Surrey. They can't stop a provincial liquor store from coming in, but they can stop anybody else who puts in an application to have a lawful store in Surrey. Now, a lot of the licensed locations that are going to be completely lawful, now they're constructed, a lot of it is to dissuade children from coming in, from it being something that children would want to go to, that young people would want to go to. Packaging can have absolutely no advertising. It's supposed to come into a silver sealed packet, and that's mandatory, and it can have no more than 30 grams of dried cannabis in it. Now, a lot of this is just to try to keep this out of the youth's hands, right? You can't promote packaging that would be likable to children, right? You can't have like a little teddy bear on it, a cobra, or anything. It's quite actually stringent for that. Cannot display cannabis accessories in a manner that can have it be seen by a young person. And you're going to walk down like Vancouver, and you're going to see these marijuana stores that are in contravention of the act, and you're going to look inside, you're going to see everything that they're selling. Now, that's going to be up to Vancouver Police Department, or whatever city you're in, to actually decide to enforce that or to let it go, or whatever they're planning on doing. If you're planning on, for some reason, trying to go for a provincially licensed outfit, provincially licensed retailer, you're going to have to get your criminal record check, and you have to apply to the city. And like I said, the city can ultimately say, no, you're not going to be able to do it. And I touched on this originally. Only dried cannabis, cannabis oil, fresh cannabis plants, and seeds will be authorized for sale. Although the Cannabis Act does say it's believed that infused edibles will be authorized within a year. So if the stores have those infused gummies in it, yeah, it's kind of a gray area where ultimately we could enforce that, but most police agencies are kind of, well, we know it's going to be authorized within a year, so why would we really come heavy on that? So under the Act, we can forward possession overage charges. When you look at the equivalency chart, if you're over it, technically we can do a Cannabis Act charge, or we can do the way of the ticket. Possession, purchase, or selling is still possible, but it makes it a lot harder for us to investigate it, because you're allowed to lawfully share marijuana with another adult up to 30 grams. So if we're in the middle of the street and I hand you a bag that has 15 grams of marijuana, there's technically nothing wrong with that. Selling, you have to purchase your marijuana from provincially licensed retailers. Otherwise, the cannabis is illegal. Cannabis is illegal. Now, that's a problem for us policing wise, because here we have a legal substance now, and is it incumbent upon the general citizenry to know that the store that they're about to go into, which looks completely professional, doesn't actually have proper licensing to actually to sell their product? So I can't speak for every police officer, but I was instrumental in designing policy for Surrey detachment. And so if we had to do an enforcement in an unlawful one in Surrey, which Surrey is not allowing them, and you happen to be in there buying marijuana in the store, you're not our focus. We have no interest in you. Although technically what you're doing is illegal, because under the statute, you're not in a lawful store, but how do you necessarily know that, which is a problem. And again, the production using solvents, that's the big one for us, because it's a huge public safety thing. If you are found in contravention of that aspect of the Act, it's going to be a charge, and we'll be investigating that with a lot of diligence. Tickets. Federal, provincial, municipal governments all have ticketing schemes coming out. The schemes are enforced, but under refinement. Now, again, everything under the Act, everything under the tickets, we're now enforcing them, but they haven't gone through the crucible of court yet, which could radically redefine what our powers are under the Act. We have the discretion for forwarding charges or issuing tickets. Our Crown Counsel can elect to either do a ticket too if they feel it's necessary. And if you dispute it, we have to write a long report in regards to what we did, and Crown Counsel is going to have to attend court. A lot of the other municipal bylaws are being ironed out and put in force. But the important thing to realize is anywhere that you cannot lawfully drink a beer, chances are you cannot lawfully smoke a cigarette. Like if you are at the Ball Diamond and you decide to smoke marijuana in the Ball Diamond, that you're probably going to get a ticket for that, because you cannot do that with alcohol. You can't be walking down the street smoking marijuana. These are all things that are enforceable and are kind of getting ironed out. But the thing to remember with that is anywhere where you can or can't lawfully drink alcohol, it's going to be mirrored with the Cannabis Act, where you can lawfully smoke marijuana or use your products. So a young person, again, a lot of the act has a lot of stipulations for dealing with the young people. Now, just like liquor, the provinces do have say in how old you're allowed to be in regards to utilizing marijuana. So in BC, it's 19. Other provinces might have it a little bit different, much like Alberta in 18 for its alcohol. However, the act does not address possession of 5 grams or less of cannabis from a youth. So more than 5 grams, it can result in a charge for a youth. And again, it's anticipated that the provincial government will fill in the void and prohibit cannabis possession for youth with additions to the Youth Criminal Justice Act. So I think that's about it for that. RCMP Resources, there's the DARE Society, which has affiliation with the RCMP, but that has mainly to do with now marijuana has become a problem in your life, and now it's more not really necessarily an addiction issue, but there's aspects of the DARE Society that can help with that. So also the BC provincial government has a really good website that kind of goes over the how much you're allowed to have, where you can lawfully buy, and I didn't write that one down, but that one's also a good one as well. Okay, that's it.
Okay, well, thank you, Ryan, so much for your presentation. We do have a couple of questions that came up. Particularly at the beginning, you mentioned an acronym THC. Could you explain what that is?
THC is tetrahydrocannabinol, and that is the actual active ingredient in cannabis that will get you high. So there's that, and there's aspects like CBD, which doesn't actually contain cannabis, which is also being touted as being able to remedy a whole bunch of medical issues. Now, again, science is studying that to see if that's valid. It seems to be, but THC is the active substance that is going to get you impaired in aspects.
Okay, thank you so much. So we're gonna go into our Q&A session. So if you have any more questions for Ryan, please type them into the question box, tweet using the hashtag AMSA events, or email them to events@amsa.org. And so in your presentation, particularly when you were looking at that chart, you used some vocabulary terms that are very specific and are many new words that some of our that newcomers generally would not be aware of. You use words such as tinctures, shatter, edibles, non-solid concentrates, solvents, etc. Could you explain a little bit more what those terminologies are? Sure.
When you look at cannabis and how it's used, there's the conventional way of smoking the marijuana bud, which is the flowering part of the female plant. You dry that up and then you cut it up and then you smoke it like you would a cigarette, or you smoke it like you would in a pipe. And that gets the THC in your system via the smoke. There's a whole bunch of methods for marijuana, for cannabis, to take that actual plant, which has the THC in it, and reduce the plant. So you're actually pulling out an oil or a substance that is a lot stronger in THC, which means much like you have a beer that is 5% alcohol and you have vodka, which is 40% alcohol, you can take your marijuana plant, which theoretically would be, say, 5% THC, it's more than that, and then reduce it down to a stronger concentrated solid. Shatter is a concentrated solid that's a little bit more like a solidified gum, whereas a tincture could be an oil that's mixed with other substances to be utilized.
Okay, and so when the RCMP teams are looking to educate individuals, particularly newcomers with lower level language skills, are there any recommended approaches to scaffolding or layering some of this content that you've utilized?
The BC government website for cannabis, I think it's BC government cannabis.com, that covers a lot of this aspect in a more of a layman's term aspects.
Okay. And do you have any recommendations for settlement and language providers who support newcomers on how to support them in this learning about the different terminologies and the different types of cannabis that you were talking about?
We don't have anything that has actually taken the way that we were trained to go forward with cannabis in the other language. I know we have not done that yet. So that's maybe something we should look into.
Okay, thank you. And so there's some other technical questions that came up. And one of the questions that came up is if there's any regulations in regards to purchasing and how frequently you can purchase cannabis. So are you allowed to purchase once per day, or can you purchase multiple times per day?
It doesn't stipulate that, but you can only go into a store and purchase 30 grams. That's the max that they will allow you to purchase. Now, if you kept going out and coming back to the store, you could end up purchasing more, but they can only at one given time provide you with 30 grams, unless you have a medical certificate saying you're allowed to have more, and then they could sell you more because of that stipulation.
All right, thank you. And one question that has come up is in regards to youth, and particularly with cannabis in schools. And so there was a question in regards to that, you know, a lot of schools have noticed that teenagers buy and sell alcohol, and so they've noticed that teenagers are also buying and using cannabis. And so does the RCMP have a plan to support the school system, the education system, with educating teenagers, but also in regards to enforcement?
Yeah, we have school liaison officers, and they've been trained in regards to the Cannabis Act, and they have resources to deal with those issues. Each school, not each school has one officer assigned to it, but an officer will have a district that she be responsible for.
Okay. And on one of your slides previously, you talked about youth age being 19 in regards to cannabis usage, but you also mentioned that tickets were only going to be issued after a certain amount of grams.
Yes.
If you could explain that, it wasn't quite understood.
It was basically, in the Cannabis Act, there's a loophole that the Act does not really deal with a youth, so someone who is under 19 that is in possession of 5 grams or under. It's nothing really in the Act that allows a police officer to enforce. But it's believed that other government agencies provincially will put in stipulations, put in aspects of like ticketing systems for youth who are in possession of marijuana.
Okay, and then thank you so much. And there was also the question that came up about the chart that you showed, and how can individuals get that chart? Where can they find it? And is there an explanation that goes with the chart somewhere in a brochure that maybe has been translated?
The one that was displayed that's from the RCMP. The provincial government does have on cannabis.com, I believe they break down that equivalency as well. The equivalency is quite complicated. It is complicated even for our membership to grasp what actually constitutes overages.
Okay. Yes, and we do have some questions regarding the impairment, particularly when it comes to newcomers. And I'm going to hold on those questions just because we will in our next presentation have 2 lawyers who specialize in immigration who will be able to answer more of those details and to answer some more of that. So I'm just going to check if there's any final questions for Ryan before we move on to our next presentation. Yeah, and there's just a great request from many settlement organizations to have some kind of translated document or some kind of document in plain language that they can use and share with their clients and with staff, and then that could be maybe translated so that they could share that with newcomers. So that was a request that's come in quite a few times here, so I'll just give that forward to you. But before we move to our next presentation, we've also gotten a couple of comments a couple of individuals have been experiencing some audio drops. So we will be moving and going to the teleconference line. So we will be continuing with our presentation in just a moment once we switch our audio settings. So please stay on the line and we will be continuing in one moment. Okay, so thank you so much everyone for your patience. We were looking to switch to the phone line, so I hope that everyone's able to hear our audio better. And so we are now going to be going to our final presentation of the day. And this is one that I hope will also answer many of your questions in regards to citizenship, to cannabis with individuals who are newcomers to Canada and the impact that it will have on them. So our final two presenters for today are Erin Roth and Randall Cohn from Edelman & Co. Law Offices. So Erin Roth has practiced immigration, citizenship, and refugee law with Edelman & Law in Vancouver. She completed a Bachelor of Arts in Political Science from the University of Alberta, followed by completing law school at the University of Toronto. And Erin has started her practice with an emphasis on refugee law, and since then has tried to expand to inadmissibility cases as well as appeals, as well as federal court applications for all types of refusals or delayed applications. Thank you so much for joining us today. And our second speaker is Randall Cohn, who's an articled student at Edelman & Law in Vancouver. He received his JD with honors from William Mitchell College of Law in St. Paul, Minnesota. Before turning to law, Randall was an outreach worker and later shelter manager for homeless youth and adults in the Twin Cities, and was a co-founder of the Minnesota Harm Reduction Community. Welcome, Randall. So we're going to continue with your presentation. I can tell that from the questions that have started to come in already, this is a much anticipated segment that I hope will bring some clarity and explaining some of the previous presentations and how this relates to newcomers.
So thank you. I'm going to be focusing for my portion of this presentation largely on possession. Possession, what we're going to call simple possession, the people who have got more than 30 grams of marijuana with them. I'm going to nuance that a little bit, or of cannabis, excuse me. I'm going to nuance that a little bit, but my working assumption here is that for the population that you all serve, this is going to be one of the most common areas of. As you all know, effective October 17th, adults in Canada can possess cannabis for personal use without a medical prescription, and our colleague from the RCMP has talked about the details of those limits, purchased from licensed retailers, for up to 4 plants for personal use. More important for our presentation is this question of what is still illegal. And I'll just note at the outset here, to avoid confusion, that this slide talks about the majority of adult as 18. This is the language in the federal act. Provinces have the authority to regulate differently, and so that's why in BC the age is 19, but the federal law says. Under the Cannabis Act, it is still illegal for an individual who is 18 or 19 in BC to possess in public space more than 30 grams of dried cannabis, or the equivalent according to the chart you have already seen. It is also illegal in BC for an individual who's 19 years older to possess any cannabis that they know to be illicit. And any person who is guilty of either of those offenses, guilty of an indictable offense, and can be imprisoned for a maximum of 5 years, let's say. Now, that is important immigration questions, reasons that are about to become clear. I want to also note about the age, that the age prohibition is significant, but for our purposes, we're really focusing on people who are adults. Now, if a youth breaks the law, has some illicit cannabis, and for a youth, all cannabis is illicit, then there still can be serious consequences, but they cannot be criminally charged. They can be charged through the Youth Criminal Justice Act. That can cause problems for them, but it can't cause immigration problems in the ways that we're going to be talking about today. That being said, it is a crime, and it's a crime punishable up to 14 years to provide cannabis to someone who is a youth. And I should have probably made a separate slide about that, but I didn't, so I want to just like lock that in, that's something that people should be concerned about, is sharing cannabis with somebody who is a minor can get them in trouble in a way that could cause immigration consequences. And this will all become a little bit clearer in the next slides. So I've put up here the old law, or the Controlled Drug and Substance Act, and law, or the Cannabis Act. So we can compare the punishment clauses. So under the old law, every person who possessed an amount lower than 30 grams, what we're calling simple possession, could be charged with a summary conviction with a maximum punishment of up to 6 months imprisonment. Under the new act, under the Cannabis Act, it is illegal for an individual to possess any cannabis they know to be illicit. So the difference here, the key difference here, is that before, well, and I'll go on and point out that the punishment clause, that a person who possesses any amount of illicit cannabis is guilty of an indictable offense, has a maximum punishment of up to 5 years, less than a day. This is significant. Under the old law, if you had less than 30 grams, you could not be charged criminally. You could be, I'm sorry, you could be charged criminally, but you couldn't be charged with an indictable offense. Under the new charge, for less than 30 grams, it is still considered illicit. It is an amount, and therefore you could be charged with an indictable offense. Now, why is that relevant here? It's relevant because under Immigration and Refugee Protection Act, which is the act that controls immigration questions across Canada, a person becomes inadmissible to Canada if they have been convicted in Canada of an offense under an act of Parliament punishable by way of indictment. Okay, so under the new law, possession of any amount of illicit cannabis can produce a conviction for an indictable offense, and that means that it can make somebody inadmissible. And I want to just take a moment here to define inadmissibility to avoid confusion. So when I talk about inadmissibility, that means that it can prevent somebody from being allowed to come into Canada, which is what you might think inadmissible means. But it also means that somebody would be who's already been allowed to come into Canada could then be forced to leave. So inadmissibility can also cause a problem for somebody who is already in Canada. Next slide. So let's just talk clearly then about what illicit cannabis is. Right? Illicit cannabis, according to the Act, means cannabis that is or was sold, produced, or distributed by a person prohibited from doing so under the Act or any provincial act, or that was imported by a person prohibited from doing so under the Act. So basically, any cannabis that was not purchased by an adult from a licensed retailer or grown according to the regulations, to the limitations for personal use, is illicit. Okay, the Act does say that you have to know that it was illicit. On its face, not knowing where it comes from might be a defense. So I'm just going to go back there and I just want to drive in the main point here, that under the old law, simple possession could get you in trouble with the law, but it couldn't get you removed from Canada if you were a foreign national. Under the new law, simple possession, less than 30 grams or the equivalent, can get you in trouble in such a way that you could be removed from Canada if you are a foreign national. And that, I think, is one of the most important takeaways for the population that you all serve. There are a couple of other permutations that I think are important to point out. Under IRPA, under a different section, a person who has been convicted outside of Canada of an offense that, if in Canada, would constitute an indictable offense, or two offenses that would constitute summary offenses, can also be found inadmissible. So you can be inadmissible to Canada because you were convicted of crimes in other countries. Now, in order to get there, then the crime that you were convicted of in the other country has to go through a equivalency analysis, where we determine, okay, there is a law like that in Canada. Convicted of this in Canada, then it would the same standard that a Canadian law would for ability. But once again, under the Controlled Drug and Substance Act, simple possession in Canada was not a indictable offense. And so a person who was found guilty of simple possession, for instance, in the United States, or under 30 grams, would not face an issue about admissibility to Canada as a result. However, under the Cannabis Act, because where cannabis is illegal, all cannabis is illicit, then a conviction for simple possession in the U.S. can now make a person inadmissible to Canada or elsewhere, right? If any amount of an illicit cannabis would be an indictable offense in Canada, and therefore would lead to admissibility issues in Canada. So a third version of this is the Commissions Clause. And I'm bringing this up out of an abundance of caution. I'm a lawyer, and that's what we do. That there is a clause by which a person can be found inadmissible to Canada for commission of an act outside of Canada that is an offense in that place. And if it had been done in Canada, then it would be a crime, even if they were not convicted of that crime. Now, this becomes relevant for two reasons. I think one, just in light of what Ryan said earlier, there might be discretionary determinations by the RCMP or other law enforcement or by the Crown about whether they would charge a ticket versus forward charges for a criminal offense or a low-level possession. However, still counts as commission. And maybe more to the point here, in the US specifically, and I think this is where people are going to be maybe running into this most commonly here in BC, some of our neighboring states in the United States have legalized possession for personal recreational use, but cannabis across the United States remains Schedule I controlled substance under US federal code. Now, this can be confusing. It means that it's still against federal law in the United States to possess marijuana for recreational use, even if the state that you're in says that it's okay. And that means that even if the federal prohibition is not being enforced by state authorities, then the act of possessing still could be considered a criminal act to make a person admissible to Canada under this part of IRPA. Now, we have heard anecdotally that some CBA officers ask people upon entering Canada from places where recreational marijuana is used, whether they purchased or consumed any cannabis. And we have not heard anecdotally that they have then, those kinds of admissions have led to an admissibility. But technically, according to the law, it's possible that they could. So out of an abundance of caution, I'm bringing this up. In terms of crossing the border, I think the main thing to realize is that it's still illegal to cross international border to or from Canada. Doesn't matter which direction you're going, so long as one side of your travel is Canada. It's against the Canadian, it's against Canadian federal law to cross that border with any amount of cannabis. I'm going to just do clear points that are in the box at the bottom here. It doesn't matter if the cannabis is legal on both sides of the border you cross. So whether you're crossing to Washington to BC, both sides you're fine. Across the border itself, you're breaking Canadian law. You're also breaking U.S. law. Even if you have a prescription for medical cannabis, cannabis is not included in the provisions of the Custom Act that allow people to cross the borders with prescription medications. Therefore, it is still illegal to carry your prescription cannabis across the U.S. across the Washington D.C. border, for instance. Okay, and violation of that law can make a person admissible. So here are my takeaways for newcomers, for people who are foreign nationals still, who want to avoid admissibility issues. Then don't buy or keep illicit cannabis. But know where your cannabis came from. Don't carry more than 30 grams or their equivalent in public. Don't travel to or from Canada with any cannabis. And the advice that I would give my clients is to be absolutely safe. If your priority is able to stay in Canada, don't purchase or consume cannabis in the US, even if you think that you're in compliance with state law. Do it legally within certain constraints here in BC. With that, I'm going to pass on to my colleague, Erin.
Hello, so I'm going to turn the conversation directly over to driving under the influence. This is one area where the implementation of the Cannabis Act created some substantial changes in the criminal code. So these are specifically talking about the potential for criminal charges and convictions in Canada. So driving while impaired, whether by alcohol or any other substance, has always been illegal in Canada. What's changed since December the 18th is the explicit inclusion of drugs and the testing for them within the criminal prohibition. So a person can be found criminally charged and convicted for driving while impaired, driving while having a blood alcohol concentration of over 0.08, which is what it's always been, but it's now a finding within 2 hours after operating the vehicle, and similarly having a drug concentration, generally within blood testing, of over the legal limit, which varies depending. I believe a lot of standards that have not yet quite been set out. And that also is included for 2 hours after operating the vehicle. Now, in terms of that 2-hour window, it is possible as a defense to say, well, I had the cannabis after operating the vehicle, and that would certainly be a defense. Now, what's also important is that when you are driving and a police officer does ask you to take a sobriety test, a coordination test, or to provide samples, this is actually a requirement under law, and the failure to comply can lead to a criminal conviction. And in fact, the criminal charges, well, the conviction and the prohibition and sentence you could get for driving under the influence is the exact same for refusing to comply with the testing. Similar to what Randall was already talking about, we have an increase in sentence here as well, but it's a more dramatic increase. So under the previous legislation, driving under the influence came with a maximum term of imprisonment of 5 years. Since December the 18th, the maximum term of imprisonment is 10 years. And this increase in punishment doesn't matter if you were driving under the influence of alcohol, cannabis, or any other impairing substance. All of them are brought under the same version of punishment. Now, what this means in terms of immigration is that we've classified 2 different forms of criminal admissibility. We have the serious criminal admissibility, and this affects everyone that is not a citizen. This is for permanent residents and foreign nationals. And what it means is somebody who was convicted of an offense in Canada where the maximum possible sentence was 10 years, regardless of the sentence they actually received, or if the actual sentence was more than 6 months. And so by moving from a 5-year maximum sentence for driving under the influence to a 10-year sentence, we've moved everyone from simple criminality under the Immigration and Refugee Protection Act to serious criminality. And it also moves for the first time to having permanent residence being inadmissible, even if they received only a monetary penalty as their sentence. So this table is basically a snapshot of the implications for a conviction for driving under the influence in Canada for permanent residents, foreign nationals, refugee claimants, and protected persons. And just to make sure with the terminology, when I say a protected person, I mean somebody who's already been found to be a refugee in Canada but is not yet a permanent resident. So for permanent residents, a sentence of at least 6 months is no longer required to make them inadmissible to Canada. A permanent resident is at risk of inadmissibility for a conviction of driving under the influence, which could lead to a deportation if they're convicted. For foreign nationals, refugee claimants, and protected persons, a conviction for DUI previously made the person inadmissible for criminality, and it now makes them inadmissible for serious criminality, which for refugee claimants is particularly important because if you receive a deportation order for serious criminality, you're no longer eligible to have your refugee claim heard. So to step back, Randall's already canvassed that inadmissibility can affect people convicted in Canada or for overseas offenses. And to quickly distinguish, it's important that in Canada, you must actually be convicted. It's not enough to be charged or to have a commission of an offense. You have to be convicted under a court of law. Now, for overseas offenses, this is not the case. You can be found inadmissible for being convicted in a foreign jurisdiction or, as Randall was discussing, for having committed the offense outside of Canada. Now, often if we're talking about a commission, there are going to have been charges laid in that foreign jurisdiction or a warrant for arrest. But in some cases, it could be as simple as admitting to a Canada Border Services Agency officer, yes, I did that. It is important to realize that there must be reasonable grounds to believe. So it's not that any possible allegation in a foreign country is going to lead to inadmissibility investigations in Canada. Realistically speaking, for driving under the influence, it's unlikely that a foreign commission would be brought forward in Canada. There likely wouldn't be an evidentiary basis for that. Randall's also touched upon it, but it's possible that me saying it as well is still a good idea. But when we consider an overseas offense, it has to be brought forward in Canada. So there has to be a way that the Canada Border Services Agency becomes aware of it. So the first step is for that officer to determine if there's reasonable grounds to believe the person was convicted or commit the offense. And that's even convicted of the offense in Canada. The officer then determines, in terms of foreign offenses, whether it is equivalent to an offense or a federal offense in Canada. And this would have to be under the Criminal Code, the Controlled Drugs and Substances Act, the new Cannabis Act, or other federal legislation. It's not enough for the equivalency to be to a provincial offense, such as the Highway Traffic Act. So, speeding in Washington State is not going to equate to an admissibility in Canada, for example. And so then finally what they do is, for the foreign offense, they look at what the maximum penalty in Canada is. And that is how the equivalency is determined. And so as we already discussed, the maximum penalty for driving under the influence is now 10 years. So this means that any overseas conviction for driving under the influence or a commission of driving under the influence outside of Canada equates to serious criminality. So, for example, if we're looking at a Canadian permanent resident, they are down in the United States and they are convicted of driving under the influence. This is even without causing an accident. This is possibly only being impaired by alcohol, not cannabis. This can still lead to a finding of serious criminality in Canada, a deportation order, and possibly loss of permanent resident status and removal from Canada. Now we're going to break this down a little bit for each division or class of non-citizen. So for foreign nationals, whether they're convicted of a driving under the influence in Canada or overseas, or if there's reasonable grounds to believe they commit the driving under the influence overseas, the result is the same. It's a deportation order from the Immigration Division. For those of you who are actually working on the front line, they will be eligible for pre-removal risk assessment before removal, and they would need special permission, or called authorization to return to Canada, to ever return to Canada. Now, I'll just say briefly, it's possible to overcome such a finding in the long term. For example, for a Canadian conviction, a person could apply for a record suspension after 5 to 10 years, depending on the method of prosecution. And for an overseas conviction or a commission, a person may apply for rehabilitation. So this would be an application to Immigration, Refugee, and Citizenship Canada to establish that despite having been convicted in the past, they have been rehabilitated and they deserve to have their admissibility overcome. And these steps are going to be the same for whether they were a foreign national, a permanent resident, or any other class of non-citizen. Permanent residents do not necessarily have to be found inadmissible to Canada and receive a deportation order. The Canada Border Services Agency will give permanent residents the opportunity to establish, one, whether the allegation is accurate, or two, even if it is accurate, they were convicted, for example, in British Columbia, why the individual should not be found inadmissible, given a deportation order, and removed. So it's possible for the CBSA to not refer a person and simply close the file, sort of a warning letter or a slap on the wrist type effect. Now, if a permanent resident is referred and receives a deportation order, as long as the sentence is under 6 months that they actually received in fact, they will have the right to appeal the deportation order. And so it's not an automatic removal from Canada. Now, what's really important to hold on to is that if the permanent resident of Canada receives an overseas conviction for DUI, they have no appeal right. So once again, that trip down to the United States where they've rented a car and they receive a conviction in the United States, the only hope for this individual not to receive a deportation order is for the Canada Border Services Agency to close the file without making a referral, because once referred, a U.S. conviction, for example, is going to be considered equivalent to a Canadian conviction for DUI. Both jurisdictions considered, for example, with alcohol, 0.08 as the legal limit. Now, just to drive the point home, a permanent resident with a deportation order with no appeal right, or who lost their appeal, their permanent residence, and is deported from Canada. Now, for refugee claimants, once again, we don't have necessarily the same level of referral by Canada Border Services Agency. They may refer the individual for driving under the influence. If the person is referred for a deportation order, once again, there are no appeal rights. So if there are reasonable grounds to believe they have been convicted of a DUI or have committed the overseas offense of driving under the influence, that's a deportation order, and it does make them ineligible to have their refugee claim considered if it was in respect of a Canadian or overseas conviction. Now, there is one clarification. I said in this case, it's the Canada Border Services Agency may not actually make the referral. And it's possible they will let the person make their refugee claim instead. And at that time, rather than say the person should be ineligible to make a refugee claim, they could argue that they be excluded from refugee protection for having commit a serious non-political crime outside of Canada. Now, clearly by the terminology here, we're not talking about a in-Canada conviction for driving under the influence, but one that was where the person was convicted prior to entry. Now, if somebody is excluded from protection, they once again cannot be found to be a refugee. But for these individuals, whether they were given a deportation order and found ineligible or excluded, they do have the right to make a pre-removal risk assessment. So their risks of return to their home country will still be considered prior to removal. Now, protected persons have many of the similar considerations with permanent residents. These are people that have already established they're at risk in their home country, and they're given a little bit or increased rights. So again, like permanent residents, they do have the ability to appeal the deportation order. in respect of a conviction in Canada for which the sentence was under 6 months. Now, if the individual is actually issued a deportation order and has no appeal right or loses their appeal, they cannot be removed from Canada unless Canada is able to establish through a danger opinion that they are essentially a danger to Canadians. Now, as a final comment, I've been mentioning the Immigration Appeal Division several times, and there's one really big risk here. So again, permanent residents and protected persons have an appeal right. So if they were convicted in Canada of driving under the influence, if they received a sentence of under 6 months, they have the right of appeal. Now, the most common outcome at the Immigration Appeal Division is what we call a stay of removal. And that's where the Immigration Appeal Division imposes terms and conditions, possibly for 1 year, often for 2 or 3 years, saying if a permanent resident or protected person complies with all of these terms and conditions, at the end of that period of time, their appeal will be allowed and the deportation order set aside. But what's really important is that that stay of removal that can be issued is canceled by law if they receive a conviction or another conviction or a first conviction for driving under the influence, because this is now considered serious criminality. There'll be no opportunities to make an explanation. If the Canadian court convicts that person, the deportation order is upheld, their stay is canceled, and they will be removed from Canada. So the bottom line for our presentation today is that the possession and use of cannabis may be legal, but criminal immigration consequences do remain. And for most non-citizens, a conviction for driving under the influence will mean a deportation order, loss of status, and removal from Canada. So I guess we open it up for questions.
Hello, everybody. This is Randall again, and I just wanted to quickly make a correction. I did misspeak about something, and I think Erin corrected me, but I want to just highlight it so that it's clear for the record that when we're talking about the commission offenses, is not sufficient to have reason to suspect that an illegal act was committed in Canada to lead to inadmissibility. You have to actually be convicted in Canada. The Commission Act is exclusively for overseas or cross-border act. That being said, the point that I was trying to make is also true, which is that although the law enforcement agencies or the Crown might be policies according to their discretion to only forward charges criminally for above 50 grams, that I would caution people to think of the 30 grams as a hard line, because those are policy decisions, discretionary, and according to the law, somebody could still end up with an indictable offense for possession over 30 and under 50. So that's it.
Okay, thank you so much, Randall. Thank you so much, Erin. Your presentation was very detailed, but we still have some questions. So if you move to the next slide, we can show how you can submit your questions. You can do so by typing your questions into the question box, to AMSA using the hashtag AMSA events, or emailing your questions to events@amsa.org. One of the questions that we received is you can explain a little bit more just driving under influence in cannabis. There was still some clarification that was being requested in regards to, is this only for cannabis or is this also for alcohol? I think that there is some clarification needed.
Sure. What's important, and actually even flows back to the first presentation today, is that impairment hasn't changed. Any driving under the influence, however impaired, is criminally illegal. Now, the criminal code has been changed to specifically start including drugs as a form of impairment. Under the former act, we had a two-step, which was driving while impaired, or B, driving with a blood alcohol concentration of over 0.08. Now they've expanded that to specifically be able to regulate not only blood alcohol content, but drug concentrations in bodily fluids, such as blood or saliva. So any form of driving under any impairing substance, including under prescription drugs that impairs your ability to actually operate a vehicle, is illegal.
Okay, thank you so much, Erin, for clarifying that. One of the questions that has come up is in regards to when they're 18 and they would receive a ticket. Individuals have stated from their understanding, for immigration purposes, an adult is 18. However, you were mentioning that here in BC, for the offense regarding cannabis, the age is 19 where you're an adult. So is that a gray zone area?
And I've just conferred with Sergeant Ryan. A ticket is not a conviction. So it is very important to go back to that. It must be a conviction to make you inadmissible. And to further clarify, any youth that's prosecuted, as long as it's through a youth court and under the Youth Criminal Justice Act, can never receive a conviction either. Youth court has the ability to impose a finding of guilt, and that's not a conviction. And again, it's only convictions that have immigration consequences.
Okay, so just to further clarify, so if a youth is 18 and goes to the youth court, even though for immigration purposes they're being seen as an adult, they would still be tried as a minor here in BC.
The 19 years old is the stipulation from the province for that. They're determining that an adult to buy marijuana or cannabis, 19. But when it comes down to criminal offenses, 18 is considered to be an adult.
Maybe this is Randall. I'll just jump in and maybe try to further clarify that. Therefore, there is this window that I think we're talking about where you could be 18 and therefore subject to immigration consequences if you were convicted of a crime for something that you did when you were 18. However, that difference, that 1 year, it's a provincial law that they have decided that the age, the legal age for purchase and consumption of recreational marijuana is 19. And therefore, if you get busted for being 18 but not 19, you are not in danger of being in violation of criminal code under a federal act, and therefore you are not in danger.
Okay, thank you so much for clarifying, Erin, Ryan, and Randall. I think that was it was a little bit of a confusion with the 18, 19, and so there was just a little bit of a confusion for individuals. The final question so far that we've received, and this is your last chance to submit your questions, is in regards to the topic of inadmissibility, or the term that you use, inadmissibility. Are you talking about people who are applying to stay in Canada only, or does inadmissibility also apply to permanent residents or naturalized citizens?
Sure. Inadmissible applies to anybody that's not a citizen of Canada. So whether that's a foreign national, like somebody here on a visitor visa or a work permit, a protected person, somebody found to be a refugee claimant, or a permanent resident of Canada. Once you become a Canadian citizen, you cannot be found inadmissible to Canada. And I guess to further clarify, it looks at the question of entry to Canada. So is the person able to be admitted to Canada? But within Canada, it looks at whether or not the person should be permitted to remain in Canada.
Okay, thank you so much, Erin, for clarifying. And the individual hasn't posted that they are seeking further clarification. So, and we don't have any more questions. I'd just like to say thank you to everyone for joining us today, for taking part in the poll questions, submitting your questions, and for really taking part in the webinar on changes to the Cannabis Act, how to support newcomers to BC. I'd also like to say a special thanks to our speakers, Anne, Ryan, Erin, and Randall, for giving us their time, expertise, and really taking us through this detailed and somewhat complicated subject matter. So thank you so much for sharing your time and your expertise with the settlement sector. I'd also like to say thank you to AMSA's team, to Cohn for working behind the scenes, all the AV, Julie, and Melissa J on social media. As I said, we will be posting the presentation, and a notification will be sent out via SettlementNet once the presentation is online. If you don't receive SettlementNet, please go to our website and sign up for free. It's free and open for anyone to join and sign up and receive those weekly newsletters. Thank you so much. Bye-bye.